Hello and welcome to episode 25 of CGI Unpacked. And today's podcast is about the Domestic Abuse and Civil Proceedings Act 2021 and specifically about the review report that we've done on part one and its implementation. So this is the third report we've done. So my name is Jackie Durkin. I'm the Chief Inspector of Criminal Justice in Northern Ireland. I'm delighted to be joined by our guests today, and they are...
I'm Julie Wilson. I'm the Director of Victim Support Division within the Department of Justice. So I would be, amongst other things, the policy lead for domestic and sexual abuse in DOJ.
And I'm Stephen Keown, presiding District Judge for the Magistrates Court here.
I'm David McAnulty. I'm the Lead Inspector for this Year 3 review.
I'm Caroline Conway. I work in the Public Prosecution Service. I'm the policy lead there for domestic abuse, stalking and non-fatal strangulation.
I'm Kerry Brennan. I'm a detective and superintendent, and I lead on domestic abuse policy and sexual abuse for the PSNI.
Thank you all. I'm really grateful for you being here this afternoon. So we know that the Act, the Domestic Abuse and Civil Proceedings Act, created the domestic abuse offence, and the Minister of Justice asked CJI to undertake an independent review of the implementation of Part 1 of the Act for at least 7 years. And this year we're on our third report. So the Year 1 review involved a case file review, and then the second year focused on the implementation of the recommendations that we made in Year 1. So this year we returned to a case file review just to see how the Act was being operated and what difference had it made. So David, I'm going to start with you. Can you tell us a bit about what the key findings were from this year's review?
Yes, well, there were both positives and negatives. We start with the positives. We thought that there has been good progress made in relation to the outcomes where the offences of domestic abuse were identified and prosecuted initially, and there was good response from police officers within time limits. And overall, we felt that once we identified domestic abuse, it went well, and good outcomes for victims. There were some issues, as we'll get to later. This was a review specifically around the theme of hearing children's voices. And we looked at a number of files through the prosecution and the police, and we found that often children's voices weren't being heard often enough. And there was a lack of confidence in how children's voices were dealt with whenever they were at scene of domestic abuse. So that was a significant issue that we identified, and we felt that a lot more work could be done. That as a theme, after 3 years, we felt it could have been done a lot better. We felt that 3 years it should have been more advanced. There's a great strategic initiative from the department from the outset, and we felt that within the organisations, maybe this is a good time for refocus to how they deal with domestic abuse across each of the organisations. There were other areas we probably come to, but the children's voice was the main key thematic.
That was a big focus of this review this year. But Carrie, can I ask you in relation to policing, not just about this year's review, but how since implementation of the Act do you think things have gone, and what your takeaways are from the review report this year?
So I think it's important to say, we're in Year 3. This is like a 7-year work plan. And I think in relation to domestic abuse and the new legislation, we have landed some of this really, really well. A good example of that is non-fatal strangulation. And it's really important to highlight that not only the arrests we make in that space, but we're sitting between 36 to 37% kind of outcome rate when that gets to court. And that offence is a really hard one to prove. So it can be due to the nature of the offence, doesn't leave visible injuries, and sometimes it can be, very evidence-led. So but the key one that one is that's 800% chance increased risk of actually being murdered by your partner if you have been subject to that. So when you look at risk factors, I think that's really positive. As a service, we're making sort of 77 arrests a month in that space. Then when it comes to the standalone domestic abuse offence, an average 85 arrests a month, which is great because we know that's about patterns of behaviour, just tools that we didn't have in our toolkit before. So we're really seeing great uptake, great compliance, like in that space. In relation to stalking, and that's going to inform a lot of our work this year. It's great that Judge Crone's here because, he's helping us in that space. But we've made 945 arrests, which is around like 20 a month. And of those, we've charged 491 people, with stalking. These were things that we just didn't have available to us before. When it comes to mandatory training, 3,000 of our officers have been trained specifically in non-fatal strangulation. So I think some of the big stuff to be sitting in year 3, knowing that that's really embedded in day-to-day practice, and our officers are identifying and seeing it is great. So I really welcome the inspection because it's really good, because even from like kind of September, the work that we've put into the child aggravator space, so that in year 3, we can put a focus and we can move on to that, and we want to put a big focus on stalking and our stalking prevention orders this year, and that's why we've been linking in with Judge Kuhn with the Judiciary, just to try and make that a bit more kind of like streamlined to protect our victims. Yeah.
So in relation to officers that are responding to a reported incident and their children present when they arrive, and I mean, we know and we've recognised in the report how difficult and complex some of those call-outs can be, and for officers to deal with them. So can you tell us a bit about how officers are being skilled up to recognise what's happening, and particularly if there are children present, what they need to do?
So obviously, if we look at the very first sort of initiative in this space, which was obviously our All Encompass, which was a really big, thing for us to do as a service. Like, we've made 56,000 referrals, since the very start of that. Our sort of next body of work, and we started it in November 2025 with Women's Aid, was to roll out a training programme called See, Connect and Safeguard, so we can upskill officers in this space, because it's about that trauma-informed lens. And when the children aren't present and they're being used as a domestic abuse offence, you're asking the officer to look beyond what they're initially seeing. So upskilling absolutely, needed to take place. So they have partnered with us, and we have a full schedule of training that has also kicked in again here, like from April, in that space. But what's happening in the wider space is that I have been working with our training, so our foundation training when officers come in. So there's a new head of the college, Bev Cripps. So we have developed like a domestic abuse action plan, and that's about focusing on officer training and getting it right, like at the front door. One of the key things that we're going to be building in is our risk assessment, our DASH risk assessment, that they get like a full day in that, because that'll really help the foundation of looking at beyond what an officer is initially responding to in this space. So some of those things are going to be really, like impactful. But I do think that awareness training and that like focus, the way we have with other pieces of legislation and they've landed, this is the focus, for us, and it has been from David and his team were in September.
Yeah, so that professional curiosity piece, I feel like, in terms of what happens. So Caroline, when it comes to PPS and you get files in and you think, right, okay, there may or not be a domestic Section 1 offence, but there are what prosecutors would think there should be aggravators because children have been present or there's issues there. So what's happening in the PPS space around that, and making sure that where aggravators should be applied, they are applied?
Well, I'll just start off by saying that we welcome the review and the review findings. In terms of the child aggravators, that is certainly going to be a big training push over the next 4 to 6 weeks, where I'm going to go out. We did train a cohort of some of our newer prosecutors in January, so that was really to promote the use of the domestic abuse offence, prosecutors to have confidence around that, using that offence, and certainly wherever there are children involved, and that's clear from the police information we have, and clear from the evidence, to encourage prosecutors to use that offence where they can. That's going to be rolled out more widely across all of our legal staff within the next 4 to 6 weeks. We also have decision trees where we have prosecutors will be able to follow a series of steps to say we'll use the domestic abuse offence and we'll use child aggravators in these circumstances. So hopefully that will ensure consistency. But in terms of work that we're going to be undertaking with police, Kerry and I plan to work very closely together in the coming months, prioritise our work and our aligned work on children. And there's going to be a QA as well to look at kind of those cases from reporting stage right through to the court outcomes. We want to explore that full criminal justice process to see where things are dropping off or where they're being missed and to respond to that.
So some of the findings from the case file review were around maybe that an offence with the Section 15 aggravator was proceeded with and maybe a Section 1 offence wasn't. Is that something that's being discussed as well in terms of how the legislation is used the way it was intended to recognise the offence of domestic abuse?
I suppose a concern for some of our prosecutors maybe in using those offences that relate to a course of abusive behaviour. If you have evidence of an incident on Monday and say an incident on Friday, prosecutors will sometimes be concerned about, whether there's clear evidence or almost like that they don't want to lose, sometimes prosecutors are more comfortable working with kind of other existing pieces of legislation and are worried about losing everything if they opt for the course of abusive behaviour offence. So you'll see there'll be very kind of complex decisions and sensitive decisions made around selecting the appropriate charge. And I think that that we're finding that out as the legislation continues to embed. So that's something we want to focus on and really provide more reassurance around the statutory alternatives of threatening or abusive behaviour and putting people in fear of violence and looking at our decision making in that area.
Thank you. Stephen, I want to bring you in here, and obviously we're delighted we have a judge participating with us, and you've been particularly active in relation to how the courts react and deal with domestic abuse when it's in front of you. So could you tell us a bit about how you think this act has made a difference and what you've been doing in relation to how these criminal offences are dealt with in your court?
Yeah, I think it's been a bit of a journey. From my point of view, Kerry was talking about getting the tools we need, and that's really, it feels like we've been on a journey to develop those tools. And I mean, from that I mean effectively the Gillen Review onwards. So we've got the Gillen Review, and arising out of the Gillen Review we had the development of remote evidence centres, and they all fed in very nicely to the new legislation and the domestic abuse legislation, and those all coming together felt like it made a big difference for the judiciary, because I'm really just interested in the practical application of the new tools we have and the legislation we have and how we can use them to most effectively. So I mean, the legislation itself immediately gave us an enhanced sentencing powers. I mean, we're talking about a 12-month sentence for domestic abuse under domestic abuse legislation. Prior to that, I would be dealing with, I always use the example of dealing with a common assault, and a bad common assault in a domestic, aggravated by domestic abuse, where I would have a maximum sentence of 6 months, and with maybe a criminal damage of the partner's mobile phone in some kind of a domestic incident and assault, where they smash, grab a phone, he grabs a phone off her and smashes the phone, and then I'm sitting there with this, as I say, a woman may be trailed around the house by the hair with a maximum 6 month sentence and a maximum 2 year sentence for throwing the phone against the wall. It just felt like a bit of a disconnect. So that was the big benefit immediately from the judicial perspective, is the enhanced sentencing powers. You're talking about 12 months for the domestic abuse offences, 2 years for non-fatal strangulation, and 12 months, in relation to stalking as well. So that's a real practical difference from our point of view in terms of our sentencing powers. But also, I mean, even having the legislation which effectively allowed us to say that entitlement to special measures was effectively automatic made a big difference. And I think people can underestimate that. I would have had a lot of court user group meetings with police down in Enniskillen and then up in Belfast when I moved to Belfast. And if you're trying to get a case to resolution as quickly as possible, so to reduce the possibility of witness attrition or witnesses complainants falling away from the process, it really doesn't help that a police officer has to go back out and knock on the door and say, "I need another statement of you in order to," in order to ground a special measures application. So there's a huge benefit from our point of view in terms of being able to say, and I was able to issue a direction to say effectively, you do not need grounding statements unless there's exceptional circumstances in a particular case. You can just lodge your application upon request, and that helps a lot. All those things are tools that make it easier for us. But you can also pull all those things together, which is what led us to develop the domestic abuse contest court, where we can, there's a tangible way of identifying cases, not just domestic abuse cases, but any case now where I can see on a charge sheet that the statutory aggravator for domestic abuse is applied, and therefore it's a case that I can channel into the domestic abuse contest court, which is effectively a contest court where only those cases are listed, so we can properly utilize the remote evidence centre. Because if you have a prosecutor with a busy list and one complainant is 10 or 15 minutes away from the court building and the remote evidence centre, it causes a huge amount of problems in terms of being able to effectively deal with your list. And so we very quickly realised that if we're going to maximise the benefits of the automatic entitlement to special measures and remote evidence centre, then you need to ring fence a court to allow us to just have domestic abuse related cases, start the court later, and have a prosecutor who is not under pressure to get to Laganside and knows that they don't need to be in Laganside till 11 o'clock and go and spend time with complainants in the remote evidence centre and properly prepare cases. And so that's made a big difference. But they're all the practical outworkings of having the legislation and the tools that we need. So that's where I see the big benefit. The domestic abuse aggravator is really important from my perspective, not just in identifying cases immediately from the outset that there is a connection between the parties, but it means that you build up, as this, we're into whatever year 3 of your reviews, but 3 or 4 years after the legislation has come into place, you can see then when you pick up a criminal record on an overnight charge on a contested bail application that any recent common assault or criminal damage, if it was aggravated by domestic abuse, it makes a huge difference from our perspective in terms of being able to identify a pattern of offending that's coming through on criminal convictions for repeat offenders. So it just feels like it's given us a lot of tools that we need in order to deal with this issue effectively. The enhanced sentencing powers, as I say, are very important, and I think Northern Ireland obviously has a bad press because the stats back it up in terms of rates of femicide, and as Kerry says, NFS, non-fatal strangulation, is a real red flag for towards that journey to the ultimate offence. So I'm reassured that the legislation has given us proper teeth. I mean, even the non-fatal strangulation 2-year maximum sentence in the Crown Court, it's 14 years, and unless I'm mistaken, the maximum sentence in the Crown Court in England and Wales is 5 years for non-fatal strangulation. So, and the Court of Appeal has made that point that Northern Ireland has taken a different path to really give, effective sanctions for this type of offending.
And can I ask you in relation to the child aggravators, and we've talked, Carrie, you mentioned about Operation Encompass, and we know from the information in the report where you go in a year where there's over 16,000 referrals and Op Encompass to a very small number of cases that come through. Is that something that you're surprised about and you expected to see more of?
Yeah, I suppose. Yes, I mean the reality is, if an offence is aggravated by domestic abuse, and there are children in that relationship, I suppose there's an automatic assumption that there's a family dynamic here that's been upset and harmed and broken by domestic abuse. So I suppose it can always be in our decision making and our factoring if you adjourn it for a probation report and you get the whole background. I suppose you can often pick up those things, but a bit like, I can't say that it's so important to have the domestic abuse aggravator to really signpost this for now and future repeat offenders, and not say that it wouldn't be good to have a bigger focus on the child aggravator. There aren't many charges to come before the court with the child aggravator on them, and when you don't have it, it's harder to identify. If you get served with evidence, it's harder to identify that one of the list of 10 witnesses maybe is 12, 14, 16 years old, you know what I mean? But through the court user groups that we have, there was a big emphasis on this, and NSPC and all the other stakeholders attend the court user groups, and there was a big focus on saying, listen, we need everybody. We need the lawyers and solicitors as officers of the court, any police officer who's connecting on a charge, and the prosecutor, and everybody to be alert to the fact that we need to flag it up if there is a child witness. And we brought in a new contest listing form. We changed it quite considerably. We have special contest courts sitting 4 days a week. As I say, one of them is ring fenced for the domestic abuse contest court. But in that contest listing form that we developed with the PPS, there's a tick box to say, are any of the witnesses a child witness? So that all we need to know is that there's a child witness somewhere in the case, whether it's a witness or the complainant or whatever, so that we can fast track or prioritize an early listing and priority on the day of contest. But yeah, we don't see many child aggravators and charges at the moment.
So sometimes the court gets as a generic term for blaming for delay, the court sometimes used, but in your experience, what do you think needs to get better to help you?
Yeah, I suppose as soon as I think we can list quite quickly whenever we have all the evidence we need. You know what I mean? So I suppose the quicker we get to a decision making process, paper served by the PPS, file in by the police, paper served by the PPS, the quicker I can. It's my responsibility to have the case listed as a contested hearing. But again, like all the other steps in the journey I talked about, we're making big strides in respect of that, in my view. I mean, it's the natural progression for me once we got the domestic abuse contest court up and running was how we can develop that. And you need to get things started before you can make them grow. As I always said, we started the domestic abuse contest court and we wanted one every 2 months. This was about 2 years ago, and we had to reduce it to every 3 months because we couldn't identify 5 to 6 cases to list every 2 months. But once we got it working and everybody, all the stakeholders understanding what it's about and getting into the way of doing the cases, and we very quickly went back to 2 months, and now we're monthly contest courts, and we're now looking at every 3 weeks, hopefully, for a domestic abuse contest court. So it's just, it's developing all the time. But the next step is that idea, as you say, to look at witness attrition. How quickly can we get them a domestic abuse case to trial or guilty plea and sentencing as quickly as possible? So that, I mean, if we're looking slightly forward, we're well down the road, as Caroline and Carrie knows, we're well down the road at looking at a fast track domestic abuse pilot for Belfast to build on the success, if you want to call it that, of the domestic abuse contest court, and to see if we can identify cases that we can feed into a more regular sitting of the domestic abuse court. So that's really what we're doing. We're about to finalise in terms of in Belfast, domestic abuse cases, overnight charges are put straight into a fast track pilot with quicker submission of PPS files, immediate allocation to directing officers, designated domestic abuse directing officers in the PPS, and a separate review court in front of me where we get cases to a decision more quickly.
So that's really encouraging what's happening in Belfast. And as we would often find, there's other places obviously outside Belfast. And as presider, can you say a little bit about what your role is in encouraging that practice with your colleagues?
Yeah, well, we have remote evidence centres. We have, I think there's 4 currently across Northern Ireland, and they're starting to be, the outworkings of the different initiatives that we have. You can see them coming out across Northern Ireland. Even in Enniskillen, before I moved to Belfast, we worked with Women's Aid to have, even though there's no remote evidence centre on or near Enniskillen, we were able to work with Women's Aid to have an effective remote evidence facility, a local arrangement, which is working well. So again, the tools are all there. We have the ability to have automatic special measures, remote evidence facilities. It's just about, and that's starting to grow in Enniskillen and appeals to Omer, where we're using remote evidence, and it's happening, of course, in all the other courts as well.
So Julie, I want to bring you in here, and this legislation's been described as transformational and game changing. So, as far as the department's concerned, are you happy with where it is? And maybe happy is not the right word, but are you satisfied that it's where you or officials and the minister intended it to be by now?
I think the Act is really important, and I think you're saying obviously that there are things that it has been delivering, and there are still areas of further focus, and I think that's to be expected in any piece of legislation. And I think the value of a review like this is that it allows organisations to focus then on what does need to change, and you've seen from Caroline and Kerry that that's what they're doing. I think the Act exists as part of a wider strategic and societal response to domestic abuse, and for me, I think it's also not just limited, the impact of it isn't just limited to what's happening in criminal justice, it's what's happening across society, across safeguarding about how we respond to domestic abuse. And I think one of the things that the Act has done has been really shine a light on coercive control. It has shone a light on, and I appreciate that we've been talking about the need for greater use of the child aggravator, but it has changed how we think about children in domestic abuse settings. It has put in place additional provision through Operation Encompass. So I think that does automatically start to go wider than criminal justice. It does look at, how are we responding to risk as a society? What's the role of Department of Health and Health and Social Care in that? How are they looking at risk? How are they understanding that pattern of coercive control? So I think the impact that it makes is really huge. We're not there. It is a journey and there is more to be done. And to be honest, I think there will always be more to be done. But I think it has put domestic abuse really front and centre as a priority, not just across criminal justice agencies, but across wider agencies with responsibilities for education, with responsibilities for health. So in that respect, I think it is really, really valuable. I think it's also informing then certainly for the Department of Justice and our partners, it's then informing about, well, here you have the legislation, what are the other building blocks that fit in with this legislation? So things like the remote evidence centres and how can they be used, but also then things like the review of MARAC and how does the introduction of a domestic abuse offence change how that multi-agency risk assessment is done, and I think overall just raising the profile of domestic abuse, both within agencies that have a responsibility to respond, but also across communities and across societies, because ultimately I think it's really well established that, and acknowledged that this isn't something that we can police our way out of. It's not even something that we can, operating as statutory agencies. It requires a whole society response. So, and I think the Act is part of that and has helped to highlight these issues as well.
Yeah. So one of the things that the department is responsible for is about publishing that information, and as part of that information and training, and as I often say to the inspectors, please don't bring me another recommendation about training, because it seems like it's like painting the fourth bridge. You're constantly saying that. But one of the things that we identified in this inspection, David, was around not just about have you done the training, but how have you applied the learning?
Yeah, that's right. I think it's fair to say the training and the planning around training in year one was well received by Prosecution Service and the police as well. But I think by year three, it was just the picture was unclear and the jigsaw pieces just weren't all fitting into place. I felt that as part of the inspection team, we thought it needed to be more of a annual reporting system that was accountable, and people knew, well, this is the difference we're making. This is what training is leading to. We have improvements, and we can then say, well, there's never going to be a perfect answer to, is this the piece that makes us all do the same thing? But it's one piece of that puzzle. So yeah, we were keen to see regular training and ensuring that it was addressing the things that we are finding. The quality assurance within the organisation should be finding themselves, and then they can act on that accordingly and roll out training year to year. I think that's the intention of the legislation, although that in itself is a moot point whether that's we wanted a fully focused response every year. But certainly from our viewpoint, we expect to see these things.
So I think what we were saying was not just to tell the department X number of officers or prosecutors or court officials have been trained, but what's the collective picture? What difference? So what difference has it made? And are people who maybe are struggling with applying that learning, what sort of support are they getting, or what quality assurance or supervision are they getting to make sure that they get the support?
Yeah, we try to look at this from like a victim's perspective or somebody from a member of the public. What does the whole process look like, not the individual parts? And we tried this in the other inspections about bringing the prosecution and defence and police all together to have a common approach, and part of that is based in the training. So consistency is key for us.
So, Julie, from the department's perspective, we don't underestimate the challenge in that, because often the department's in a position where it's reliant on good quality information coming in from other parts. So can you tell us a bit about what the department wants to do in that space?
So I know that I recognise that the review saw a role for the department in particularly in reporting on more analysis and on the effectiveness. And I think there is a limit to how far the department can go in that without actually overstepping our role in terms of the operational independence of Prosecution Service and Police. And I think so I would be hesitant, and I think anything that we do in that space needs to be really informed by operational partners as to their assessment of the effectiveness. And I think there are ways that the effectiveness of training can be assessed. I don't think that it's an exact science. I think you can, any kind of performance framework around that is going to look at kind of outcomes in terms of victims, and and really we should be looking at the effectiveness of training. I think how far the department can go is very limited, and I think actually the Act is qualified as well in that reporting requirement, and says that it's around the department providing analysis and views so far as it finds appropriate. And I think there's that appropriateness is really important when it comes to operational independence. Don't know what you think about that in terms of police training and prosecutor training.
We obviously have like a joint governance structure, in place where we meet bi-monthly, and obviously training is one of our if you like agenda items, and we're trying to do a lot more kind of like joint training together. I suppose that we're both like sitting kind of like in that space, and we can like hear from experts, like in this like field, and then we can like talk about like for us, how we can kind of like utilize that, because like the Public Prosecution Service, like they're independent and they have to hold us to account. It's something that has to meet the evidential standard, or it doesn't. So it's good to have that kind of like, I feel like robust, like effective partnership, in place, and that's kind of how it should be. But I do agree with you, like Julie, I think it's really for us to look at our own, like impact and how that translates. Like there's a number of things that we're trying to do in this space to give victims more choice. So this year we are going to be bringing in rapid video response, RVR, in Northern Ireland. It'll come under our virtual officer attendance team, and we'll call it vote safeguarding. And that's a victim choice, and that's about having specially trained domestic abuse officers who can engage with the victim like remotely, and all of their evidence can be gathered that way. And that allows us then to, if you like, measure effectively, the quality of how that's being done, all with the victim's choice. And just going on Judge Keown's point, that will speed things up for our partners, as well. It also means like things like the child aggravator, that we can be really specific, in our training when supervisors are, reviewing those like calls. But more importantly, it helps us tackle hidden domestic abuse. Like we have so many people where they don't want the visibility of being at the police station or police at their house, because domestic abuse doesn't discriminate. It's everywhere in society. And it's about giving victims, like another choice. It also has a translation service as well. So you're not delaying things, and we're able to maximise, like a technology, there's 23 forces in England currently use this. It's considered to be the gold standard by victims. It helps tackle victim attrition rates. So as a service, we're not only thinking really innovatively about how we can do it, but it's about making those big system shifts in order to respond to the pandemic that is domestic abuse in our society, and encourage everyone, to be able to come forward in a way that they're comfortable to do so.
So that partnership working that's done with the Public Prosecution Service, it's not about, I feel like, very important though it is, about operational independence, but it's about making sure that you support each other in terms of good quality investigation files that are going to save time and resource for the Public Prosecution Service as well.
Yeah, that's correct. And that's certainly kind of the main kind of focus of the gateway teams. Gateway teams have set up, at magistrates court level and now Crown Court level, and they are they're prioritising domestic abuse cases. So those pilots will look at the file standards, making sure that all of that evidence that is part of the file build essentially is coming in, that all reasonable lines of inquiry are followed up quickly, and then that case is allocated quickly and a decision is taken, and that case is put into the court system. So I think that's working very well at the minute.
There are lots of, like, RVR is one example of like a new initiative that's coming down the line. I think that there are lots of those, and probably every single one of them requires some sort of training need. And so I think the challenges of that rollout of training are really significant, but also I think they kind of layer on top of each other as well. So work around the changing MARAC, moving from MARAC to domestic violence and abuse risk response, that's going to come with its own training opportunities and training challenges for police and for wider. I know that I'm going to send you down another line of questioning with this, but with the introduction of domestic abuse protection notices and orders will also then create training needs, training opportunities and training challenges as well. But all of that knowledge and that kind of layers on top of what's gone before.
It really is about the sum of the parts, isn't it? And every organisation has a part to play, and certainly the Act intended.
Looking at it from the court's perspective, I have noticed an improvement. For example, I think early police response times are really important, because the one time you will get an account as to what happened is in the immediate aftermath of in the immediacy of the incident, which is the incident that has caused this complainant and victim to pick up the phone to police. So early police response times and the recording of an initial contemporaneous account in body-worn video is hugely important, because and then subsequent initiatives to try and capture and keep complainants is hugely important, because that's going to really affect victim attrition rate. But with an early response, I've noticed a real improvement in terms of police recording initial accounts in body-worn video, which means that you will often get conviction even when a witness is disengaged from the process, under res geste hearsay applications. But I have noticed, and I mean, I was talking about the domestic abuse contest court, started off, slowed down and then speeded up dramatically, because it was a slightly slow burn at the start, and then once people started working it and working the system and understanding it, then that's where you really get traction. And I just think that's the same across the board in terms of the outworkings of good training, is that you see better quality body-worn video applications before the court, and then if we can build on that by getting the cases to the decision stage and ready for a trial more quickly, and in between times, if there are police initiatives, working with the PPS to hold on to complainants and in a maybe less overt way, putting them under less pressure, it'll all come together and work really well.
So I want to finish up by asking each of you, we're into year 4 now, so if we're all back here this time next year, just in a few words, what would you want to see happen in the next year, and what we're likely to see next year when we come back? It can be aspirational. We'll not hold you to it, don't worry. Julie, do you want to start with you?
For me, within the next year, probably the biggest thing linked to the Act will be the introduction of a pilot for domestic abuse protection notices and orders, which we're currently working towards the launch of that in the second half of this year. And then I think that there are other wider initiatives in that kind of strategic space that are around victim care. And I think domestic abuse is an area where having a trauma-informed response is actually really, really critical, and cuts to the kind of victim attrition. And I think there are opportunities. We need additional resource, but there are opportunities there that we can really make a transformative changes in those spaces. So those are the changes I would like to see.
Curtis? Well, I want to see that this time next year that we're dealing with 1/3 of domestic abuse incidents like other forces, like kind of like online, where the victims chose to do that, because we know that'll improve like outcome rates, and it cuts down the time it takes like for an investigation as well, and also tackles victim attrition. But more importantly, that's about like getting the right people with the right training. And then secondly for me is like the training piece. And it's about that kind of like centralization of it, like kind of within policing, and really leaning into the benefits of joint training, especially with our partners within the Public Prosecution Service, and not doing those things like in silo, and really just like embedding that. Like we're already seeing outcomes in the child aggravator space from we started, and that training in November, which is really encouraging to see, because we obviously it's important to measure, is it working? And that's why we renewed like that work in this space. So yeah.
Thank you, Caroline.
I think there's a lot of very good work going on, and it's kind of working with Kerry and the police to keep that momentum up. And certainly we're working at kind of refreshing our action plan, following through on that. Child aggravators are going to be a real big focus over the next couple of weeks, and probably looking at new ways to share information so that it's consistent and not a number of different documents, so that it'll be clear front and center whenever a family kind of set up has children who may have witnessed that abuse.
Stephen, can I ask you what you'd like to see in the next?
This time next year, I'll be telling you all about the high percentage of overnight domestic abuse pilot charge cases that the police are hitting the 21 days file submission with body-worn video to a designated directing officer who's specifically dealing with domestic abuse trained cases, who will have been allocated that file within 3 days of it being landing in the PPS, so that on the fourth Thursday after the first appearance, I'll be having domestic abuse cases that are about to or close to having a decision issued, so I can then take it from there to get them listed for plea and sentence or regular sitting in the domestic abuse contest court shortly thereafter.
David, as a lead inspector, you're getting the last word. What do you want to see next year?
I'm going to try and remain positive. So it's just that point around consistency and resilience. There was some really good work done in year one, and let's keep the focus going towards year 7. So that by year 7, all the good points that we mentioned today is becoming common practice for day to day, and that we are getting no delay, and everyone knows what they're doing, and we are fully accountable, and that we are on that end journey towards ending violence against women and girls and domestic abuse.
Thank you all for participating in the podcast today. Really appreciate your time, and thank you also obviously for the great work that you're doing in relation to tackling violence and abuse against women and girls and domestic abuse in our homes. Thank you.